Okay, the next section, section 3, transactions with persons other than clients. This section simply deals with any type of communication with a third party. All right, the first thing is communicating with a person known to be represented by counsel. So a lawyer may not communicate with the person the lawyer knows to be represented by counsel in the matter unless the lawyer has the consent of opposing party. The rule is designed to protect a person who has chosen to be represented against the possible overreaching by other lawyers who are participating in the matter. So this rule applies even though the represented person initiates or consents to the communication. You've got to get consent by opposing counsel. Just because, if I'm the plaintiff in a case and opposing counsel wants to come talk to me, he can't talk to me if I'm represented. And even though I said, no, it's fine. No, you got to get the consent of my attorney. Because lay people sometimes don't understand the things they say. It could be harmful to their case and helpful to the defense or the other party. So that's why you need the advice. You need to make sure you get the consent of opposing counsel. Now, when it comes to the case of a represented organization, so in the case of a represented organization, a corporation that's got attorneys on staff, a lawyer may not communicate with an employee who has the authority to bind the corporation or whose statements may be imputed to the corporation, unless, of course, you obtain the consent of opposing counsel. So again, when you're dealing with a corporation and you talk to, and it's represented by counsel, and let's say you're talking to one of the higher ups, you can't talk to the higher up without the consent of the corporation's counsel. Simple as that. However, this rule does not apply to former employees. So if you want to talk to a former employee of the corporation, that's fine because they're no longer part of the corporation and they're not covered anymore. So the rule is not prevented, though. It's not to prevent parties from talking with each other. So the plaintiff may call the defendant even if both parties are represented by counsel. I mean, essentially, why not? They're allowed to talk amongst each other. Generally, you let counsel handle it, but if they want to, maybe they'll get together, they'll negotiate it, they'll come to a mutual agreement, and hey, we don't need the lawyers anymore. So keep remember, if the person is represented, you may not communicate with the represented person unless you have the consent of opposing counsel. If a person is not represented and you want to speak to them, you can, but you must not state that you're disinterested in the matter. You have to explain to them, hey, look, I'm representing somebody else whose interest may be adverse to you. Do you still want to talk to me? You don't want to mislead the person who's not represented. Okay, truthfulness in statements to others. In the course of representing a client, a lawyer must not knowingly make a false statement to a third party. A lawyer is required to be truthful when dealing with others on a client's behalf. So a misrepresentation can occur by misleading statements or omissions that are the equivalent of a false statement. So if you tell a partially true statement that omits facts, that's a half-truth and it's misleading. You've learned that in contracts. So don't forget, whenever you deal with a third person, you can't lie to a third person, conceal your identity. You're required to be truthful. Simple as that. Now, what happens when you receive a document that you know was sent inadvertently? If a lawyer receives a document that was sent inadvertently, the lawyer must promptly notify the sender in order to permit the sender to take protective measures. Additionally, the lawyer may not use the document to her advantage and may not read the document any more closely than is necessary to ascertain whether it's privileged. I don't know about you, but guess what? I'm going to need to read the whole document to make sure that I'm assured that it actually is privileged. That's normally what people do. But you can't use it. You're supposed to stop reading. But I mean, how are they supposed to know that? How are they supposed to know when you actually know that it's privileged? I mean, you might have to read the whole thing to ascertain whether or not it's privileged. I'm just kind of trying to be funny there. I'm not really making the joke hilarious. But anyways, you may not use it in your case, and you must notify them. So the step says, when you get a document that was sent inadvertently to you, notify the sender. You may not use it, and you may not read it. Simple as that. And that's all we got for section 3 that deals with transactions with persons other than clients.